We have an agenda that Jill has distributed to all of us, and it's part of our packet. I'm not very good at formalities, despite my years in the legal system. I'm calling the meeting to order. I'm advised that enough members of our work group are here to constitute a quorum, so I think we're ready to go. My suggestion would be that we defer the first item on our agenda, which is discussion of our annual report to the council and the executive, that we defer discussion of that topic until later in the meeting, because I think the discussion of several other topics will affect the report that we'll be wanting to do to the council and the executive. Satpal, I want to welcome you to the meeting specifically, and thank you for coming to our meeting. Tell you in person that it's nice to see you, at least virtually, after more than a year now. Yes. I'll let you all know that from my perspective, retirement is going very well. I like it quite a bit. There's quite a bit to recommend it. And nonetheless, I remain excited about this committee and the work that we're doing. Along with Dr. Peterson, I would think I attended the National Center for State Courts seminar this morning on pretrial services agencies, and really recommend this seminar. Got me pretty excited and gave me some good ideas. And I think that'll be coming up further on in our discussion here. Satpal, are you here simply as a participant and observer, or is there any specific message you'd like to be giving us?
No, I'm just as an observer, and I have only 20 more minutes and I have to go to Everson. So I just wanted to watch the proceedings of this committee, and yeah, thank you.
Okay, great. Well, we're happy to have you, and we know you have a lot on your plate, so we appreciate your giving us this time. Does anyone have any suggestions for changes to the agenda for our meeting, or shall we just launch right into it? Okay, I don't hear any suggestions. That puts, does everyone agree that we should come back to the first topic, identifying the content for our report to the executive and council later in our meeting, so that we can launch into the more substantive discussion? Is that okay with everybody? All right. Okay, I see one thumbs up. I don't hear any objection. All right, couple thumbs up. That's what we're going to do then. Thank you. Let's go to item 2, unless anybody has a different suggestion for the order in which we address these topics. Shall we go to item 2? And that's you, John Kraus. Are you ready to launch into that discussion?
Yeah, well, just kind of a brief scenario update on the status and use of pretrial services unit. Currently, we have 108 on our caseload. Actually, this is taking a week of these numbers, so they deviate by a couple, but and we have 3 levels that usually people are assigned to, defendants are assigned to. That's low, medium, and high. And that's medium has 61, the low has 31, and high has 16 defendants. Actually, case numbers, not depending on how many cases are assigned per defendant. This is what that's measuring.
I'm sorry, John, could you go through those numbers again? 108 defendants total.
Yep.
And 61.
Medium level.
Okay.
16 high level. And 31 low.
Thank you.
And from, let's see, February 2020 to March 2020, we did the PSA, and then it was lifted for a year. And then from April 2021 until present is when we started using the PSA again. And exactly how many we've done, I could just say it's in the hundreds since then. And they're done on all new arrestees at first appearance calendar that are in custody. And those who bail out or don't have a first appearance won't receive one. And we don't do them on DOC warrants or fugitives or drug court or other diversion programs since they're under another jurisdiction. So if they end up on a first appearance calendar, we won't perform those PSAs, which is still very small, but just to help you discern who we're doing. They have a year-to-date check-in reporting rate from the beginning of the year until now is 80%. And then all of last year reporting in rate, that's just those who are required to check in via electronically, telephonically, in person, was at 84% a year ago. And that's kind of consistent with the national average of check-in between 76 and 86% that they have to make contact with pretrial services.
Okay, John, I'm going to interrupt you with a couple questions. I'm going to save most of my questions, but the ones that will affect how I hear the rest of your report, I'm going to ask questions now. And I'll ask other members of the group to do the same thing, defer all but the pretty critical questions. But I do have what I think is a pretty critical question, and that is, you said that defendants, I guess I want to know the point in time when the PSA is done. I had been believing that the PSA is done before the defendant comes in to court for a first appearance. Is that correct?
That is correct, if they're in custody.
If they're in custody.
Yeah.
Okay, so all of the people in custody have the PSA done before they come to court for the first appearance, right?
Unless they are released prior to the first appearance.
That was my question. And that would be people who are released when they're at the booking point.
Yes,
of the
somewhere in
process.
that process, yep.
Okay, all right, thank you.
Okay.
Please continue.
Drug court has also asked us to get a little involved with them with identifying potential drug court recipients over if they're put on pretrial services over a period of time. We can give them the idea and see if they'd be a good candidate for drug court and submit them. We go to their regular meetings weekly and just say, here's maybe some potential drug court defendants. And then we're working with them. We just started doing that about a month ago. We were invited in on that. So, and we'll maybe help perform some other duties with drug court, maybe field contacts possibly or something with them. They're still working on some of the details. When their caseload grows post-COVID, they've asked us if we can help out with a few things. And then the software that we use from the vendor is expanding and upgrading their system. That they've taken over some major contracts across the country on the federal and local and state levels for pretrial, probation, diversion court. So they're really expanding out. What they want to do is expand out to help us collect and catch more data. And I think that would kind of lead into what Dr. Peterson will be talking about later is, or what we want to start looking at for gathering more data, and specifically what is this software we can have the vendor tailor make it to what we want to catch. And so that's something hopeful that we can start more specifically looking at data as we gather it here in pretrial. And so that's just kind of what we're doing just day to day. And then the other question on here was ideas to help reduce the pretrial population from jail. Simply start sentencing them, or well, not sentencing, but assigning them to pretrial. We haven't really had a referral in a couple of months. We've just had very low referrals all the way through, and majority of our caseload was assigned. Some of them been on, most of them been on up to 2 years. So I would just say start assigning them that are appropriate on a nonviolent charge in lieu of bail or lower bail, however that wants to be looked at. If you want to, start looking at a policy that judicial officers can recommend automatically assigning specific nonviolent crimes to pretrial services. Those who will be, after they look at it, kind of automated, saying, well, this is a good candidate, and we all agree. You know, if you make some sort of guidelines that you want to use to more streamline those sent to us. At some point in time, we could monitor EHM on specific clients, defendants, violation reports or compliance reports with EHM on certain defendants. They can come into our office and we can send those into the court.
Do we have any defendants on EHM now?
Not under pretrial services. There is some, but they go through the work center, I believe.
Okay. And
EHM for specific DV cases or high PSA scores on the safety assessment. If there's still high bail or lower bail, you know, have an EHM put on with their PSA score for those who have high bail, or if you want to lower it and they want to release, you know, that can be assisted in there too. Some sort of policy making regarding some of these ideas. So that's just kind of what pretrial is up to from day to day and what we can do to help lower the jail population, just right off the top of our head.
For the 61 people who are on medium level services, how frequent are the contacts between?
At this point in time, they're supposed to be monthly.
All right. And those are phone conversations currently?
Phone contacts, correct.
Okay. And the people on high level services, how frequent are those?
They come in weekly, contact weekly, either phone or in person, or we're still under some COVID policies. So that's in change, in flux.
So it sounds like there's some phone contact and some with in-person contact?
Correct.
Okay. And the low level?
They're at this point, they're same as medium, monthly phone contact.
All right. Alan Epps, I didn't notice you here in the beginning of the meeting, so I didn't greet you, but hi. And
Hi.
Thanks for being here. And would you like to add any comments or ideas to the ones John's given us?
No, John has wrapped it up very well.
Okay. All right. Any questions for John and Alan from others in the group? Dave Reynolds, anything you'd like to add?
Yeah, one thing I've questioned, and John and I have talked about this in the past, is have we identified really a kind of central area where there's barriers for people making it to court and things we can do in pretrial that would improve showing up? I mean, like transportation, or I know we're doing text reminders to everybody, whether they're on pretrial or not, to remind them their court dates. But have we seen a pattern of what it is in Whatcom County that keeps people from coming to court when they're supposed to? Have we been able to identify any of that with, you know, what we've seen over the last couple of years?
Yeah, and of course, in order to do that, we need to have a better sense of how many defendants aren't making it to court. Now, I'm a little not current in my knowledge of the court's practices, but I know that partly due to COVID, the court has really reduced the need for defendants to appear in person at court, which perhaps Judge Freeman can tell us more about that. And I'm sure Maya can update us too on how that's been going. You want to talk just a little bit about defendants appearing in court for pretrial hearings, what's required now, and how that's been going? Judge Freeman, why don't you start, and then Maya, I'll ask you also to discuss that.
I mean, the two primary times that the defendant is required to be present or via Zoom would be at a trial date, and an arraignment date. Those are the two that come to mind. There was a change in the court rule early 2021 that essentially relieved the duty of appearing at the status hearing prior to a court date. Largely, that has remained in place. A judicial officer has to find good cause in order to require a defendant to be at a non-mandatory hearing. And I think that is done fairly cautiously, and Maya can kind of share her experience with that, but I don't see that happening regularly on calendars. There have been some times that we are requiring it, maybe for a confirmation hearing the week before trial, just to ensure, given that we're still in COVID protocols and we're coordinating juries coming in, just to be sure that things are actually going out the next week. But that has substantially reduced the amount of hearings that a defendant has to appear for, because if there's an agreed trial setting order ahead of time, they're not going to have to come in for that trial date. That'll get continued ahead of time on their attorney's request. And we're really not seeing anyone regularly. The Wednesday calendars, as far as status, it's primarily an attorney calendar now. So.
Okay, so when you say defendants are, is it that defendants are only required to appear in person if the court orders it? Is that right?
Absent their trial date, yes, essentially. They would have to appear for an arraignment. Arraignment and trial date are the only two that I can think of that there would be an absolute requirement absent a court order or a judicial officer ordering their presence.
Okay, and when we talk about the defendant appearing in court, we're talking about being physically present in court or attending by Zoom, is that right?
Generally, yeah.
Yeah, okay. All right, good. Maya, do you want to add to that?
I think it's working really well. And usually there is a requirement that the individual appear for the Thursday trial confirmation, the Thursday before the trial. So generally, I think there's like 3 times that they have a mandatory appearance.
All right, that's great. And do we have anybody here from the prosecutor's office to offer that perspective? Doesn't look like we do today. Okay. All right, John and Alan, do we have any statistics? And Dave Freeman or Dave Reynolds, pipe up if you need to. Do we have any statistics on the defendants who are currently on pretrial services, how their what their rate of compliance is in terms of making their required court appearances?
We haven't really been collecting those things since we don't track the court case. When we do our periodic criminal histories, we see what happened, if they're on warrant or not, and where the warrant stemmed from. But since we have district court texting all the court dates to them, we don't keep track of those or capture all that information.
And what do we have in terms of statistics for defendants on pretrial services being arrested for a new offense, violent or otherwise? Do we have those statistics?
We've got a running tally we're sending to Dr. Peterson to kind of add up the percentages, more specifically tied into name, case, demographic, those kind of things.
All right. And Andrew, do you feel like you're getting the statistics you need to keep an accurate tally?
Yeah, I haven't been able to build one yet, but John and I are working on getting those files together. So he sent me now a full roster, and I have also the roster of those that have failed for a new charge or new arrest. So I just have to put those together. But yeah, I can send that out to the group.
Can you give us some sense of what those statistics are?
Well, there's some clarifications that have to be done because it looks like some of the cases that were closed, their status, their outcome is hasn't been updated. So I want to check with John on some of those before I do an analysis. Just to make sure that I'm using the right numbers, you know, that I'm not overinflating.
Okay. Did you attend the seminar this morning with the National Center for State Courts?
I didn't. I had a conflict this morning, but I was able to attend the last two that they had.
Okay, good. I don't know about the ones that you attended, but I thought the one that I attended this morning was excellent. Very helpful. And perhaps after the meeting, Andrew, you and I can talk about getting a link to that, because John and Alan, I really think that you should hear this seminar that I heard this morning. It's from the Pretrial Services Unit of the Washington, D.C. court system, and the discussion of their intake process. They use the PSA, and their results are just excellent. But their pretrial services are more intensive than ours. It's not possible for us to simply adopt the pretrial services that they offer for lots of reasons, including the fact that they seem to be able to recommend and require pretrial defendants to be in services, including mental health and drug services. And I don't believe the law in Washington would support that kind of order. But nonetheless, the discussion of the services that they offer in terms of identifying barriers to compliance with the pretrial court orders, I thought was very good. And I would like John and Alan specifically to hear the lecture from the Pretrial Services Unit person from DC, because I thought she gave an excellent presentation full of good ideas. So Andrew and I can work together to get a link for that. I'm sure the seminar was taped and will be available to hear, but it was a good one. Thank you for letting us know about it, Andrew. I was really glad I went. Yeah.
Good. Yeah, I'm glad. The two seminars that I attended, I thought were also excellent, and the links are up there, and they're usually posted within a couple days after the seminar. So I'd expect by the end of the week there should be a link to the one this morning.
Okay, good.
I have one other question for John. Oops, I'm sorry.
I was going to say Stephen Gockley's had his hand raised for a little bit now.
Oh, Stephen, I'm sorry. I didn't notice. Go ahead.
That's okay. I was just following up on your request for questions of John and Judge Freeman, if you want to go first. Okay. John, Monday, the task force adopted a plan to compile data reports from all throughout the system to circulate them amongst task force members, ultimately to post them on the website so the public has access to the information that we're working with the task force as well. I'm not sure. I sort of have a sense that you compiled the data you just reported to us for this meeting. I don't know if you have a regular reporting thing, even just to Dave, perhaps. But if you don't, I'd like to encourage you to formalize that on some regular basis, and maybe let us sweep that into our index committee, which is our data accumulation effort within the task force, so that we can make that information available to everybody who's trying to work with it.
Yes. Email specifically what we'll see how our software can pull this in. It's kind of limited right now, but with it expanding, we certainly would really like to know what, and we can have our vendor work this into the program.
Would you mind if Lieutenant Caleb Erickson in the corrections staff is sort of chairing that? Would you mind if I put him in touch with you to?
Well, certainly, that'd be great.
Okay, And Dr. Peterson, to the extent you have any reports on your analysis of our data, I would ask if we might sweep that into that data dissemination effort as well.
Sure. Yeah, I'll be able to, I'll send along what I have.
Thank you both.
I just had a quick question for John about administering the PSA. John, is the PSA given if an individual has a new offense and they've got one pending already? Do you re-administer the PSA at that point?
If they're arrested and booked in and they're waiting for their first arraignment, yes.
Okay. All right. Thank you.
I think you're probably waiting for me to unmute. So can you hear me? Yeah, okay. One of the things that was mentioned today in the seminar that I recommend so highly was the DC PSA Pretrial Services Agency people, the acronyms get kind of confusing. They re-administer the PSA frequently. Perhaps if there's been any change, they have monthly contacts with defendants or more frequent than that contacts. And if there's any change to a defendant's circumstances, and of course they talk about that in the contact, they'll redo the PSA to see if there's any improvement in the defendant's scoring. And if there is, and or if the defendant does very well in terms of compliance, then they'll look at reducing the frequency of contacts or reducing other restrictions in the defendant's pretrial services order. In other words, in the requirements that the defendant has to comply with for pretrial services. I wasn't entirely sure how much of that is done with the agreement of the judge and how much is the discretion of pretrial services administration, but that too is something to think about. And I'll be interested to talk with all of you further after you've seen the tape of this morning's seminar. Other ideas for pretrial services or questions about pretrial services? And I tell you, I have to step away from the computer for a moment. I have the volume turned up, so I'm going to be able to hear the discussion, but I'm going to mute my computer so that when I step away from it, you don't get that background noise. So I'm with you and I can hear you.
Judge Freeman or Maya, can you update those of us who are not in the thick of things on how trials are running and what the case flow is looking like now and coming up? I'm trying to get to my regular question of Dr. Peterson. When are we going to have enough data to validate post-implementation? So I'm interested in the case flow right now.
I got muted first. I guess I'll go first. I mean, there are trials occurring right now too. So that's like a doubling of the trials we were having before. So that's progress. And, you know, I watch every week sort of the lineup. I've got like they send out a roster going out for now. I have until May 16th that lists all the pending trials. And I think that with trials happening, we are seeing more settling and movement in cases. That certainly helps. Sometimes you have to get up to the eve of trial and see if the state has witnesses or is prepared, and then offers come and cases resolve. So 2 trials now running and more movement of cases is how I see it.
So this is probably where the question would normally come in to me. Or Judge Freeman, sorry. didn't mean to
I was
do
just going to agree with Maya as far as, I think we have a pretty good system in place to run 2 trials at a time now. It will be difficult to get us up to maybe a third, but that's potentially the case. The one, I think, practical issue that we're dealing with right now is that I am in a multi-month trial. So that's really taken up one courtroom. And so in reality, we have one other trial going at a time. So.
Okay, this is Judge Garrett. I'm back in front of my computer and unmuted. And thank you for continuing the discussion while I was out of the room. Anybody? Oh, you know, Adam Fryer, I wanted to ask you about how, about whether you have any ideas about the LEAD program working more effectively with the pretrial services program. I mean, we'd like to tie those 2 programs together as much as possible. Is there anything you'd like to add on that subject?
Well, as one of the case managers and both of my supervisors are here, I think they would be a little bit better at answering that question, how we could coordinate with them. But as a case manager in the thick of things, working with clients to get to court on a regular basis and fight those barriers and challenges, I think that it would be a great way to collaborate from our perspective. I think working with the public defender's office has been a great collaboration. Yeah, I think that would be more of a question for Melora and Tommy to see how those services could connect a little bit better, but I think that would be great.
Yeah, I can add on that a little bit, Adam. And I just to clarify, and I'm very new to these meetings, but I know that we're discussing pretrial processes. I think I want to emphasize there really isn't a wrong door or a wrong referring agency who can provide a referral to LEAD. At any point within the legal system, someone can provide a referral to the LEAD program. And that would simply be writing a referral form or giving me a phone call, writing me an email, a fax, any method of that. And then what we would do is bring that individual through an operational work group where we actually have law enforcement, a representative from each agency in Whatcom County, as well as a public defender. Maya attends this meeting, as well as a probation officer, program managers from therapeutic courts, from drug court, mental health court, city attorney, as well as the prosecuting attorney's office. And we would all go over this in the individual who's been referred to our program. And from there, depending upon this individual, whether that individual is deemed fit for the LEAD program, we would initiate outreach for that individual. And so that's kind of what that referral process would look like. If there's any questions about how to make a referral, please reach out.
Is there any process, and thank you. Actually, I'm going to turn my video on for a minute. I'm sitting here eating my lunch, so that's why I don't have my video on consistently, but I'll put it on because I want to introduce myself to you, Tommy. We have not worked together, and I'm glad to see you here in this meeting and in this work group. And Melora Christensen, and the same to you. We've not formally been introduced, but hello, and I'm really glad to have people from your program here involved. I had met Adam previously, but didn't realize, I don't know that much about the LEAD program. To introduce myself, I'm a former judge, but I've been off the bench since January of 2021. So I need others to update me about actual practices. I'm very glad to have the LEAD program involved in our pretrial system generally and in this group specifically. And I do, is there any regular institutionalized or formalized system for contact between the LEAD program and the pretrial services unit? at this point, or is it less formalized than that?
And I guess my question is, are we referring to this specific subgroup? And when we think of pretrial processes services?
Not with pretrial services, the pretrial services unit, not so much this work group, but the pretrial services unit and the lead structure. I don't, you may all know the answer to this, but I don't. Just, do you work together frequently, or is it as, you know, as the need arises, or how does that work?
Very much on a case-by-case basis. I mean, I think Adam, you could answer this as well too, but I think it's very much on a case-by-case basis in terms of how involved the specific client is enrolled in within the legal system, how much they're engaging with the lead program, because the lead program is completely voluntary as well. So yeah, very much case-by-case basis, but we have been engaging. I think public defenders have been our primary contact as well.
Yeah, I would agree. I think pretty much whatever the stipulation of the court and taking the guidance of the person's public defender, if that person has to engage with pretrial services, we just assist them with contacting them, getting cell phones, getting the resources they need to stay engaged. So that's kind of how we've been connecting with them. Just, yeah, case by case.
So earlier, John described a relatively new line of communication between drug court and pretrial services unit, where the unit might suggest a possible referral for exploration. Is that the kind of thing that you mean by case, or would that be sort of a step up in coordination, a little more direct suggestion from the pretrial services unit?
Absolutely. I think it's really ultimately, with both of those programs being voluntary as well, it's really up to what the client wants, essentially, right? But with that said, if a therapeutic court manager as well as the public defender deems that it would be appropriate for that individual to be in both drug court and lead, or mental health court and lead, then it is a possibility. And we do have currently enrolled lead members who are actively within drug court and lead, as well as mental health court.
Okay, you know, Tommy, I don't know if you or Adam or Melora is the right person, but I'd like to talk informally with one of you outside this meeting, so I have a better sense of the lead program and what you're doing, and how lead program services can interface, if that's the right word, with pretrial services. I'm not going to take up the time of this meeting to essentially come up to date and learn about the lead program, but I'll be in touch with one of you, and between the three of you, you can decide who's the one that would be best able to talk with me and give me a...
Deborah, I'll just jump in here, and really nice to meet you and others that I haven't met. Melora Christensen. And I am the response systems manager for the health department and oversee the Grayson lead program. And Tommy and Adam both would be the right people to connect with that, and really good folks to have on this work group as well. I don't think I'll be able to continue being here, as lead is very well represented by both Tommy and Adam. But if there's other things that I can help with, Deborah or others on the call, I see there's not a chat function, so I'm not able to put in my information, but Tommy or Adam can connect you with me as well. Thanks. Oh, you're muted, Deborah.
I'll look forward to working with all of you on this committee's work. Ideas for streamlining referral system to lead. I think we've probably covered some of that, but that I was not at the February meeting, so I'm not sure specifically what part of that discussion we're following up on today. Tommy or Adam, would you like to address that?
I mean, I'm trying to, for lack of a better term, you really just have to think about it. You just have to think about the program and whether this individual would be a good fit for the lead program. And at that point, I would bring them through an operational work group process, and it's really up to the operational work group who will decide upon the matter on whether that individual would be a good fit for the lead program. But yeah, I mean, there really is no wrong door. I mean, you just have to think about making a referral. I can provide some contact information as well to this group, everyone in this group, if that would be helpful.
Tommy, it might be helpful too to also get the eligibility criteria to everyone so that they understand what we're looking at and what could make someone ineligible.
Yeah, absolutely.
And I think from my knowledge of the services that pretrial services provide, I guess it's just a question if you feel like that individual needs that extra support, you know, that extra intensive case management that can kind of see them as regularly as needed and, you know, help remind them and keep track of their court dates and stay in contact with the public defender in order to make it to court. I mean, that's pretty much a lot of our job is just getting people to their court dates. So we're kind of serving the same function. I think the intensive case management role is just, you know, it's if you feel like you need that person needs that extra support. And in a lot of ways, you know, when we're talking about like the pretrial risk assessment, I wonder, because in the beginning, the presentation about the data that's being collected, it was mentioned that individuals in diversion programs are not getting the risk assessment. Is that correct?
That is correct. They're in another jurisdiction and they're so they don't really, our tool is used for release to see what kind of level they should be released on and if or what kind of conditions if they're in custody only.
Gotcha. So that's what I wonder too, is how somebody enrolled in a lead being in itself a diversion program, how that affects their score. If that knowledge is known, how is that known if they're enrolled in the lead program? Because we really try to knock down those barriers to get people to court and connecting with their public defender. So some other things to think about.
John and Alan, let me ask you this. Do you feel, are you in regular touch with the LEAD program? And do you feel like you know the services that the LEAD program can offer? Or would, would a meeting on that be helpful?
Yeah, a meeting would be helpful. And we started this discussion Maya brought it up in the February meeting. So that was just a very quick discussion and initiative. But before that, we didn't use the LEAD program or really know about it. So that would be good. Yes, because we have clients that we could identify and possibly recommend over to LEAD. And if Jill wants to send out their contact information, we can find out and see if they'd reach out to certain people. We can let LEAD know, through email or referral or something of that nature.
Well, homework assignment to you, John Kraus. Will you please be in touch with Adam, Melora, and Tommy so that you and Alan Epps can arrange a meeting with one or more of those three LEAD program representatives to talk about your common goals and how you can do referrals so that, as Tommy mentioned, it's on your mind when you're talking with people. And I mean, I'd rather duplicate services there than have people slipping between the pretrial services unit and the LEAD program. So homework assignment for the 5 of you to make a plan to get together and talk about interaction between your 2 programs. John, I'll ask you to be the lead on that, no pun intended, doing the scheduling of the meeting and reporting back to our next work group meeting about the meeting that you've had. Okay.
Good.
Okay.
I'll need their contact info. That's all I'll need, and then we'll go from there.
Okay.
I have a follow-up question. Sorry to be the example of 2 steps forward, 1 step back, but I need to take a step back to make sure I understand the interplay here. The risk assessment is for people who are sort of in a prosecution track. And I'd understood lead to be a diversion outside that track into a more of a treatment or a coordinated services track. And I understand that lead probably can, by referral, pull people out of that prosecution track. Is that what we're talking about here? Or am I misunderstanding the sort of the parallel but somewhat separate paths that those 2 systems are working? Adam or Tommy?
Go ahead, Adam, you are muted first. Muted.
Well, I was going to say, Tommy, you might be able to answer this better. So John, sorry, Stephen, to just clarify your question. You're saying that people in pretrial are heading towards prosecution. Lead is your understanding that there is diverting away from that. I think your initial assessment of lead was correct in that we kind of, our referrals are people who we're trying to walk alongside them throughout the criminal justice process that they're going through, wherever that process is at. I mean, if somebody is definitely on their way to, being sentenced to prison time, I think that's a viable discussion that we have, is like, is this person appropriate for lead? Are we able to connect them to services so they don't keep cycling through the system? Is that appropriate here? But yeah, I think, Tommy, if you want to add anything else to that, I mean, we really are trying to like stop the cycle wherever it's at. And that's kind of where we fit in.
Yeah, I mean, I think just feeding off the back of Adam, what Adam is saying there, I mean, I think what we are to really do is provide a helping hand throughout the legal system to allow someone to feel less alone, essentially. I think when we take part in, we actually provide surveys to our lead clients at certain points within their enrollment. And the majority of clients within the lead program all remark on feeling some form of resemblance of being alone. And so that's, I think, the big thing to think of is, does this individual need social support of any type? Does this individual need transportation assistance getting to court? Things such as that. But something to keep in mind as well is that we are here to meet them where they are at, physically and metaphorically. So if they are not ready for treatment, that's something to keep in mind. Maybe we can help them get to that point through motivational interviewing.
I think my question went to whether the purpose of the LEAD program was to provide an alternative to prosecution for the crime, was to turn the case into a more treatment or social service connected remediation of the situation. So someone who is being prosecuted and at risk of incarceration either would need to be extracted from that and benefit from the different approach that you all provide. That's what I would have pictured, rather than walking alongside of them as they head into trial and perhaps conviction and perhaps incarceration.
And so I think now I understand your question. So, and Tommy, correct me if I'm wrong, we kind of have two types of referrals that we're getting right now. So we do get referrals from the prosecutor's office, which is a diversion. But we also get community referrals from any community agency, even individuals, family members, anyone that can be enrolled into the LEAD program. So yeah, and Melora probably, and Tommy can probably elaborate a little bit better on those processes, but it seems like we have two tracks, I guess, that kind of nail what you're saying.
And so I guess I want to hear the people who have their hands raised, but well, maybe I should formulate my question a little better before I go ahead. Judge Freeman, I think you had your hand up.
Thank you, Stephen. Mine was just a very brief comment to stem off of what Adam had mentioned, and that is that I don't know what it would look like as far as judicial officers receiving this information, and whether somebody was involved with lead, but I can say, in my view, that would be very relevant information, whether it comes by way of the PSA or some other additional, whether from a defense attorney or from pretrial services. But it seems to me that that is a very, very relevant question. And I think the last thing that we want to be doing is also piling up appointments and things of that nature on an individual. And I can see that affecting whether we put somebody on a high level of reporting if they're already involved with lead. So I don't know how it would come to us, but I would hope that it does.
And Stephen, I'm happy to just speak to your question and comment in that what the legal system decides to do in terms of someone's charges or recommendations from the court, we at lead don't have any power over that, right? And so we can give as much information as is appropriate of what that person is working on and make sure that we are, advocating and making sure that the judge and the defense attorney has the information that is needed, that's relevant, but that we're really here to be advocates for the individual as they navigate the legal system. And hopefully our involvement could change the way that plays out because there's more information. But it's not that, in King County, for example, they have assigned specific prosecutors to the lead program. So that is something that this county could do, but that would be, up to our prosecuting attorney's office. We can help advocate for that or give information on how that would impact our program, but we have no power over that legal system except to say we're here and we are working very closely with the individual and can give more information. I don't know if that is helpful.
Yeah,
addresses.
That helps. And I think if I boil down my question or my lack of understanding, it is when Tommy or Adam referred to or encouraged people to make referrals, and you would see whether they fit the criteria for lead involvement. I guess I realized I don't know what it means to fit those criteria. I know at one point I looked at the acceptance criteria, but when Adam described working on either of those tracks, and I know there are some exclusions for the kinds of charges made, but otherwise it looks as if anybody's open to engaging with your support and advocacy, they might be in.
That's right. If they've been referred and they meet the criteria and the operational work group approves them, and we have room on the caseload, which right now we do, then we're going to do everything we can to engage that person and enroll them, and then work with them on their legal issues. And if that, that allows the team to work closely with the courts. But again, it is voluntary, but the good news is that we have outreach workers and we don't give up easily, right? We continue to try to engage. And even if someone isn't interested, and so we return the referral because of lack of engagement, they can be referred again. So it's not like we wouldn't be able to engage again because they might be in a different place in 6 months and 12 months.
Stephen, it sounds like you and I should both meet with Tommy and or Adam to talk about the lead program and what it can offer, because I think we both need to cover some basics there. So after this meeting, I'll send an email to Stephen, Tommy, and Adam to make some plans for setting up a meeting. We can do it in person or by Zoom, whatever the preference is. And that should bring you and me up to speed, Stephen, and I think we could both use it.
Yeah, I didn't realize how much I could use it until we got into this, and thank you all three of you for best efforts to bring me up to speed here.
Yeah, my sentiments exactly. So good. Okay. Do we have anything further on that issue? I think that pretty much resolves it and lets us move on to item 4 on our agenda, which is Dr. Peterson's description of the Thurston County validation and the materials on that validation, which were in our packet. Dr. Peterson, those look like pretty good results. What do you think?
Yeah, and I think for anybody looking at it, I would agree. That this was not an validation that I did myself. They had an outside person because this was all done through a grant, a technical assistance grant that was given by the Arnold Ventures to support. It was actually Thurston and Pierce have had this done now. Yeah, I didn't have the results from Thurston in my email and shareable like I did from Pierce, like I did for Thurston. And I know the people at Thurston a little bit better just from other projects. And so it was easy to share this. The group that did the validation was a group called the Research Triangle Institute, or RTI. They're really well-known kind of private research data analysis group out of North Carolina. They have been, they have a lot of high-profile people in this realm. So it's not unexpected, or it's expected that they would be one of the people involved. And my role in this was just preparing the data, really. So I took the data from the Thurston County Jail in this case, and also the Pierce County Jail for theirs, combined it with the AOC court data so that they had statewide criminal histories and some sense of sentencing, because prior incarceration is a factor in the PSA. And then also combined it with Washington State Patrol arrest data. And so that they had, because the outcome measure is new arrest, or one of the outcome measures is new arrest. And so then we sent that data to RTI. And so you could see in the appendix in there, and maybe it would be helpful if I could share my screen and we can kind of, go through some of the highlights together. Is that possible?
1 minute to give you that.
I'll do my best to fill in the meantime.
Okay, good.
So,
Okay, go ahead.
oh, great. Hold on 1 second while I try and navigate this. No, I don't. Are you seeing my desktop or are you seeing the packet?
I think it's the,
Oh, wait, let me try again. Okay, is this do you see summary of APPR?
Yes.
Okay,
Yes.
great. Great. I've got 2 screens going and it's not this. I'm new to 2 screens. It's been a game changer in terms of my productivity, but I'm not so versed in sharing and all these things with that. So, so looking at it, they made a couple decisions in there, which I think, I understand from a research side, but could complicate things or at least cause more questions. So one is, I think it's kind of common sense to look at each individual racial ethnic group in the data and see, be able to compare across. Unfortunately, certain racial ethnic groups are just, they're not very large in Thurston County anyways. And so because they're so small, to do the types of analyses that they wanted to do, it would have been difficult. It would have been very meaningful because the numbers were so small. So they kind of grouped everyone into either persons of color or white. And I can see potential issues there. Another one is just a factor of the data in that Latino individuals. So the way the data are collected, there's a race category and an ethnicity category. The ethnicity refers to whether they're of Latino descent or not. Unfortunately, in there, for whatever reason, and this has been an issue that I've been pressing lately, is that we have a large, and this is true in the courts and in arrest data, we have a large number of missing ethnicity data, and it's about probably a quarter of all records in the courts or in arrest are missing the ethnicity data. So that does 2 things. One, it's likely to undercount the amount of Latino defendants or arrestees in the data. And two, it probably overcounts the white individuals involved, because in about 95% of the cases, if the ethnicity is Latino, the race is classified as white. So if that ethnicity is missing, then they're just going to look, they're classified as white. So that's an issue in there as well. And so for that reason, they say they didn't, they saw the same thing, that I've seen with this missing ethnicity. And so they didn't factor in the ethnicity into the racial category. So that causes more questions, and it's something that has to be looked at. Unfortunately, there's not, because it's missing, there's not a lot they can do right now with that. It's just something that, we're trying to push and improve the data in order to get more meaningful results, hopefully. That said, though, just looking at the racial categories, they look to be relatively well distributed in terms of outcomes being relatively the same across, in terms of who's detained, who's released. Males are overrepresented, but that's true throughout the justice system. And the scores also were very predictive. So if you put up with my scrolling for a little bit, I want to go down here. Oh, one other factor I should add, the State v. Blake decision came out kind of in the middle of this validation, or actually near the end of it. And so they went back and removed cases where the only real conviction, or the only eligible conviction, would have been a felony drug possession case. So those weren't in this examination, just if anybody has, if that was a concern for anyone. But I think the table that, sorry, is there a question?
Yeah, my question is on the first page. I didn't understand the 6th bullet point. All detained individuals could be matched to a released individual with a similar profile. If you want to address that now, that's fine. If you prefer to put it off, that's fine too. But I just didn't understand what that means and what the statistical implications are.
Sure. What's saying in essence is can we compare those that were detained to those that were released? So they want to, you want to compare apples to apples as best you can. And it's looking at our release decisions. Would they have matched up well with the PSA recommendations? If you're looking at from a release recommendation. So are judges very predictive of the risk of new offense, basically? So the fact that they could match up all of them indicates that there are a lot of detained individuals that either are maybe would have done well on release, or would have been low level if you had done a scoring system. And also conversely, there could be a number of release that were high level or high risk to reoffend.
So that really ties to how much the judges are following the various, how much the judges are making decisions based on the levels.
Yes, in this case, no, because this is retrospective data. This is all historical data. So this is data that these are cases that happened or bookings that happened before the PSA was in place. So they went back and kind of retrospectively, what would this person have been scored? Right?
I get it. Okay.
Yeah. And so it's saying that the factors that the PSA uses don't appear to be the same factors that the judges use, at least consistently.
Okay, thank you.
Yeah. And so that actually comes up down here just a little bit. It was one of the points that I wanted to do, or one of the little tables that I wanted to emphasize. So this is the average PSA scores by release status. So what it's doing is comparing the detained and the released individual groups and looking at the PSA scores on 3 factors: the risk of or likelihood of failure to appear, likelihood of new criminal arrest, or new violent criminal arrest. And the scoring is 1 to 6, and so these are the averages. So you can see the detained, their risk was 3, just under 4, where release was 3.5. So there's really not that much difference between them, which is really what they're getting at, is that they're given the low levels of relatively low levels of new criminal arrests, new violent criminal arrests, slightly higher, but still, I think the risk of or the likelihood, the amount of failure to appear was only about 25%. So given those likelihoods are relatively low, what it indicates is that there are a lot of people detained that, if they had been released, probably wouldn't have either committed a new offense or even failed to appear. Let's see. And also to the matching. So this was the other factor that I wanted to highlight. So looking at this is kind of what they call the validity measure. So this is the AUC, it's the area under the curve, and that name isn't important. What the way it's measured is it takes a group of individuals that were not successful on pretrial release and randomly matches them up to a group of people that were successful. So you have the same number, and then it compares the PSA scores. And what it says is how often was the successful person, how often did they have a lower score than the unsuccessful person, right? So how often was a successful person a 1 and a unsuccessful person a 6, or vice versa? And the higher the score means more often the successful person had a lower score, right? So it's a measure of how valid was this instrument, how well is it predicting. So what you'd expect is the lower scored people are going to be more successful than the higher scored people, right? If it's 1.0, that's perfect prediction. Every time an unsuccessful person had a higher score than a successful person. If it's 50%, that's a coin flip. It's 50-50, meaning it's not very successful. Most risk assessments fall in the 0.6 or 60% to 70% of the time. And so this was towards the upper level of that, 60-70% that you see most often. And that indicates that it's relatively good and much better than a coin flip, although no one has gotten close to perfect yet. So that's an overall good sign for the risk assessment.
Okay, I must admit, now I understand, thanks to your explanation, but as I was reading this, getting ready for this meeting, when we got to the area under the curve, I was lost. So it looks like these are fairly good numbers, but there's clearly room for improvement.
Yes, there's always room for improvement. And there have been some that are better or have gotten higher scores that way. However, there are drawbacks to those as well. They often involve interview questions. So it takes more man hours to do those kinds of things. They have to be hand scored. You can't automate them nearly as well. Where the PSA is all static factors. So it's all things that are, you don't need to do a separate interview for. You can just, based on the criminal history.
So the bottom line on this, do you find this information, preliminary as it is, indicative of a bright future for the PSA?
I do. Yeah, I think it seems good. Like you said, there's always room for improvement. And I think they're going to, I know for a fact they're going to continue to validate this going forward. So as it goes into actual use, and as theoretically more people get released, if judges continue to follow the advice from this validation and the reforms that have taken place, you know, it would be interesting to see as more people get released, do these numbers hold up? And that's something that they'll continue to measure.
And did you say that you have seen the results from Pierce County? They're just not compiled in a summary form like this?
Right. Yeah, I didn't have a form that I could share from them.
In terms of consistency, how consistent were the Pierce County results with the Thurston County results?
So they were very similar in terms of the demographics and kind of equality, or not equality, but relative similarity between racial and ethnic groups. The one area where it was a little different was in here, as you went down the matrix of risk scores and appearance in court and new criminal arrests. This is kind of almost a perfect stair step. Is this the one I want? Sorry, looking for the right table here. Yeah, so this one is almost a perfect stair step down. So as you increase in level, risk level, these numbers will decrease. In Pierce County, there was, I think, between like the 4 and 5, it was more similar, or might be slightly, the 5 might be slightly lower than the 4, or slightly higher than the 4, kind of thing. But it was otherwise largely the same.
As I looked at this, and you're here for your expertise. We certainly don't have that in me. But as I looked at this, looking at the failure to appear and the yes to a crime, but not the violent crime, seemed that the big drop off on both of those was between scale 3 and scale 4. Whereas on the no new violent crime, the big drop off was between 4 and 5. I'm not sure what that means, but I was struck with the fact that they weren't parallel there.
Yeah, it's a good question. There, especially with the new violent crime, it's a pretty rare event, as you can see. I think the numbers they have earlier showed, it was only 3 to 4% of cases had a new violent crime. And so with rare events like that, it's harder to predict, like meteors falling or something like that. It's, it's not quite that rare, but it's just harder to predict because it's so uncommon.
Thank you, Dr. Peterson. Does anybody have any questions for Dr. Peterson on that Thurston County report?
David. Or Judge Freeman, sorry.
Yeah, I just wanted to make sure that I'm understanding what was being measured in Thurston. Thurston used the PSA in both district and superior courts. Is that correct?
These are, it's based on jail bookings. So this is, and I think just felony jail bookings. So this was just superior court case.
Okay, so it was just felony bookings. Okay, I misread that. Thank you.
No, that's okay.
And this is based on statistics compiled before Thurston County was using the PSA, right?
That's correct. Yeah. So it was bookings between January 1st, 2017 and December 31st, 2018.
Okay. All right. I think we can move on to the next agenda item unless anybody.
Judge Carol has had a question for a little while.
Oh,
I'm
I'm
sorry.
really bad at observing that on the screen. I'm sorry, Carol. Go ahead.
Oh, no worries at all. And I'm having trouble getting my questions clear. But one question that I had was, did we settle for Whatcom County on what we were going to use as a definition of a violent crime for purposes of the PSA or for purposes of determining pretrial success? And I'm curious what Thurston County's definition was, but mostly that was a reminder to me to ask if we know what our definition is and if we're being consistent about that in the application of the PSA and in tracking pretrial success rates.
That is an excellent question, Carol. I wish I remembered the answer.
Yeah.
And I just don't. I remember we talked about it, but I don't know that we actually defined the charges that would qualify as a new violent crime. Maya, do you remember? No? Stephen? Or Andrew, do you remember?
Judge Gary, I think I remember, or I have a recollection of contacting somebody at Arnold Foundation and getting a list of the RCWs that Yakima used.
Yeah, starting to ring a bell.
And then I sent those to Maya's predecessor and to the other day at the prosecutor's office, and I don't remember if any were settled after that, but I can see if I still have that list somewhere.
Now that does ring a bell as well, and I remember going through and maybe making. I feel like I did go through and make maybe one or two changes of crimes that I didn't think would qualify as violent, but I don't know where it landed ultimately.
Am I concerned here, which I know we've talked about before, and it sounds like maybe something that we'll come back to, but in our communications about pretrial services and monitoring and our validation of the PSA, I guess I want to be clear, because I think the statutory definition of a violent crime is so much more limited than what community members might assume if we said, you know, only this small percentage of pretrial defendants have committed new violent crimes. I just think it's really clear, important that we're transparent with our definition there, and that we're looking at areas where the community might have concern.
Well, I know that for drug court for a long time, the definition, there was a question about whether the definition of violent crime included burglaries, and specifically residential burglaries. And we're going to need to address this question for sure. And I guess the sooner the better, right, Andrew? Because it's going to affect how you analyze the data.
Absolutely, I agree with that. Let me go back through my email and see if I can find that list. And in the meantime, I'll also reach out to Thurston and Pierce and see if I can get their list maybe. So that might help with kind of triangulation.
If I could squeeze in one last question for Dr. Peterson. The Thurston County evaluation was all retrospective historical data, I think you said. You did the same kind of analysis on several hundred cases that Dave and Bruce sent you for us, if I'm right. Were the findings that you got on our data similar to what Thurston County got in this more formalized assessment?
You're testing my memory a little bit, but yeah, I think that's correct. Yeah, I remember that there were, let me see. I think there was in Whatcom, if I remember right, there was a little more difference between the detained and the released populations than we saw in Thurston, which is I think a good thing for Whatcom, frankly. In terms of those that were detained would have had higher risk scores on average than we saw in Thurston. But otherwise, yes, in terms of the release groups, we just saw that kind of stair step movement that shows a kind of a correlation between the risk score and the percent that were unsuccessful on release.
Well, if you can get that information to us, Andrew, we don't have anybody from the prosecutor's office at the meeting today, and I wasn't at the last meeting, I believe, the February meeting. So I don't know if Dave is still participating in the group. Have you talked with him about these things, Maya, recently? Probably not. Okay. I will contact and find out whether he's going to continue in the group. And if not, then I'll contact Mr. Ritchie and see if we can get a new appointee from that office, because we need a prosecutor in the group. I think that finishes our discussion on that point. Believe it or not, we're getting there. I'm aware that we're going to end our meeting pretty soon. The discussion of data analysis continued from the February meeting. Is that something you'd like to address, Andrew?
If I recall, that's just kind of what John alluded to earlier on which factors the group would like to have measured and keep in track when it comes to pretrial. I think I'd sent out, I hope I'd sent out the measuring what matters document already, which is kind of a subsidiary of the Department of Justice had put out with help of pretrial people from across the country, including actually Thurston County's pretrial director was in there. And it just lists a number of factors that they recommend tracking, or at least considering tracking, in terms of both outcomes and also performance. So you have things like outcome being success, and performance being number of people that are evaluated. What percent of the people at first appearance have a score, right? Are scored or not, or what percent are referred to services or get a text message reminder, that kind of thing. So that I think is, it's up to the group. You don't have to follow that. There may be certain priorities that are much lower for you to track, and there may be some things not on that list that are of interest. So especially if the software has potential to be changed, I think it's a good time to think about that, and then maybe set a time to review and come up with a list. Just you're on mute.
Thank you. Sorry. Handing out homework assignments here. John and Alan, can you work with Andrew to compile a draft list of those factors?
Yes, yeah. We'll be in touch outside the meeting.
Yeah, exactly. And then at our next meeting, we'll look at that list as a group and figure out whether it needs fine tuning or whatever, so we can finalize that list. Is that workable for you, Andrew?
Sure. What we could do, in fact, is kind of set up a draft list, and then what I've seen done with other counties, or when I was sitting in on Thurston and Pierce, they came up with a draft list and then they sent it around to the group, and the group would kind of rank, the list for most important, least important, and then then they had a sense of priorities.
Okay, good. Yeah, good.
Excuse me, I would say that if you guys want to do that kind of a ranking, please filter those questions and answers through me, so I have a record for public access, and to not run afoul of the Open Public Meetings Act.
Great minds on a single track, Jill. I was just going to ask that you be the contact person for that. You're the most reliable emailer too.
Happy to do it. Thank you.
Before, I think that finishes our discussion of data analysis. Before we get much further, let's figure out about a meeting schedule. I suspect a couple of us are going to drop off before at 1:30. I'm not, but I think that as pretrial services comes back up to speed and we're looking at these various questions that are before us, we need to be meeting more frequently than we have been. And I don't know, I'd suggest meetings in May and June anyway, and we'll see where we are. We may be able to not schedule meetings during July and perhaps August. I'm thinking monthly meetings, and my schedule is suddenly much more flexible than it was before, so I'll defer to the group on times. Let's start with what we're doing now. It's a Wednesday, and I think we're what, the third Wednesday? Is that workable for the group? Or are there other times? Do noon meetings continue to work best? I'm going to leave it to whoever'd like to comment.
Well,
I guess-
I raised my hand because this is my third noon meeting in a row this week. It is Wednesday, and they are all task force meetings. It is a huge ask and very draining for me. And I think asking people who are employed to work through their lunches consistently is really inhumane and not right. Like, I would prefer to put meetings during the workday so that people like take care of themselves and eat their lunch, not on a blackened screen trying to. I just, that's how I feel. I say this at every task force meeting that I'm asked about this subject. I frequently, they're scheduled at noon anyway. I get it. People are busy, but I subject to it fundamentally, I think so. And I know it's hard for, I mean, judges are, we're all in court. We all have things, but that's just how I feel. Thanks.
Well, what would you suggest? If you were the scheduler, what would you do?
If I was the what?
If you were the scheduler for a group, what would you?
I would probably do one of those, I don't know how to do them, but I would do one of those things where people put in the list a bunch of appointment times and people fill in the dots about when they're available, and I don't know, a poll of some kind, and then a Google poll. I don't know how they do them, but I see them all the time for other types of meetings, and pick the one where the most people can be there.
A doodle poll, Maya.
Thanks. Stephen probably knows how to do them.
No.
In terms of, I mean, it seems to me that if we're going to have regular meetings.
You're muted, Judge.
Judge, you're
I
muted.
thought I was. I'm sorry. If we're going to have regular meetings, we need to have a regular time rather than different times in different months. And so I don't know. If not noon, I shudder at the thought of before 8, ending before 8:30 in the morning time. If that's the group's intent, I'll go with it, but it sounds horrible.
What is Judge Freeman? Yeah, I'd like to hear what Judge Freeman's schedule.
Yeah,
Like, I think he's probably the one of us who's most obliged to things.
Yeah, I don't know if we want to set it around my schedule, because quite honestly, the next 2 months, it will be difficult for me to attend any time. So I think at least for May, June, I'm really only available before 8:30, the noon hour, and potentially I could squeeze something in on Fridays before my civil calendar. But otherwise, my intent, if we go forward at noon, is to still try to be here as much as I can, but I'll be honest, I've been working through the lunch hour most days on trial work. So we might not want to base it around my schedule, is what I'm saying, at least through June.
Okay, well, assuming that, my suggestion is going to be, what would you think about scheduling the next 2 meetings for noon hours in May and June, while trying to figure out a better way to do it going forward from there? And if we were to do that, everybody can participate in saying, what times work best for them. But in the meantime, is there a day of the week, assuming we're going to bite the bullet and go with noon meetings for the next couple months anyway, is there a day of the week that is preferable or not preferable? And let's start with Wednesday, since that's what today is. Is that a workable time for people? If we were to say the third Wednesday of the month, or the first Wednesday of the month, or whatever, is that a good time?
So Judge, first Wednesday of the month I actually have is the day of the Thurston County pretrial group.
Okay, and you know, it's also the meeting of the Bar Association as I think about it. So, I don't know. Maybe we should just pick some dates.
I want to ask Jill because number one, I really appreciate how involved Maya has been in all these meetings that she just recounted for the task force. And I know occasionally there is a week in the month where there are fewer task force meetings, and there are others where there are 4 or 5 or 6 packed together. So Jill Nixon, can you, am I right in that? And can we pick, if we're going to have a new meeting for a while, can you pick a week where there are fewer meetings and will be less of an imposition on Maya's well-being?
For the month of May, the week of May 23rd to 27th, so that would be the 4th Wednesday, there are no IPRTF meetings. That would be May 25th, Wednesday, May 25th. And probably either June 8th or June 22nd. There are no other IPRTF meetings. Does May 25th work?
Anybody object to May 25th?
At noon?
Okay, hearing no objection. Our next meeting will be May 25th. And the meeting after that, June 22nd? Yeah, any objection? Speak now or, okay. June 20th.
The times are at noon again? Oh, you're muted, Deb.
In the meantime, everybody, please give some thought to scheduling during work hours as Maya suggested. And if we were to do that, what times would work for you? And as we get closer to that date, we'll circulate some kind of correspondence on that. Okay?
Adam, yes, noon for May and June.
Got it.
Thank you.
Okay. Then the last thing, not that we're going to cover this substantively now, the annual report to County Council and County Executive, identify the content. Jill, do you want to just tell us briefly what's?
Yes. So the annual report to the County Council and County Executive is due the end of June 30th. The steering committee for the task force is currently building that report. And if we're going to include a section for this group, we'll need to get that figured out. I think there was a lot of great discussion today, and I have a lot of notes for good content for that report. I think just a quick short paragraph on background and current use statistics, collaboration with drug court lead and the public defender's office, improving the case management system to improve data collection, and next steps, which could include developing a regular report on current use, increase referrals, possibly through a judicial policy, the possibility of doing electronic home monitoring for PSU clients, need to identify barriers that would improve people showing up in court, and consider how participation in lead or drug court will impact a PSA score. Those are my notes from today's meeting. I can leave it up to one of you to draft this section. I can draft a section and have someone here take a look at it and add to it or change it or fact check it. How do you want to move forward with that? I will need probably a preliminary draft by May 2nd.
Okay, well, if I get my druthers, I would say option 2. You've got the best notes, Jill, I'm sure. And perhaps you could write up a draft and circulate it to the group. I know it's hard to write stuff as a committee, but we'll circulate it. People can comment as they like. And if we need to, we'll put together a subgroup to go over it and finalize it. Is that workable for everybody?
Sounds good. Thank you.
Okay, good. Thank you, Jill. All right, I think that covers our discussion. I'm not sure, the next item on our agenda is public comment, and I'm not sure that we have anyone here wishing to comment, but if so, now's the time.
There are no attendees for today's meeting.
All right. I think that covers all the work that we needed to do in today's meeting then. Does everyone agree? Okay, that enables us to finish our meeting. Thank you. I think we had quite a productive meeting today and moved the ball along, and that's a good thing. We advanced the cause. So thank you all, and I look forward to seeing you on May 25th, and it sounds like we will be in communication in various ways in little subgroups between now and then. All right. Good to see